24 minutes to. We just want to welcome I'm just welcoming Ulrich. Once again, Ulrich and GSM team, thank you so much for sponsoring this event. It's been well worth it up to now. We've had on average 30 people, 30 folk joining, which is fantastic. And Ulrich, let's go ahead with what you can share with us.
Great, no, it's an absolute pleasure to sponsor this event. I think it's such a wonderful thing what you're doing, David, and Lee, for sharing your experience with others. I think that's the goal of life, is to get better, better as people, better as professionals, and these events are so wonderful. So absolute pleasure to be part of it, and thank you for the opportunity. So I'm so sorry for you, for the legal slot at the end after a long morning. What a way to end. So I'm going to try and make it engaging and interesting, and I'm trying to push it through for 20 minutes so that we can finish on the dot at 12. So please keep track for me, David. If I'm going on, please tell me to move it. But I should be finished within 20 minutes. But I thought, just in the vein of being real, I think I'll start with a bit of a joke, a lawyer joke. And it's always funny telling jokes online because you don't hear people laughing. But I'm just going to go ahead anyway. I think in life it's very important to laugh at yourself, and the attorney industry or lawyers have a bad reputation out there, and it's one of my roles as a lawyer to change that perception out there, that lawyers can be real and can be people, and not all lawyers are, as Lee said, not everyone is how everyone perceives them to be, and we are out there to change the view of lawyers, and that we are approachable, we can be real. We can be engaging. We're not all arrogant. We're not all full of ourselves. So this is my joke. So when a lawyer dies, why do you bury them 12 feet under instead of 6 feet under? The answer is because deep down they're really nice guys.
That's a good one.
Thanks for laughing, David. Thank you. Okay. Okay, so today I'm going to be looking at the concept of small issues, big problems, and looking at some scenarios, trying to make it as practical as possible. Areas where I have experienced issues, where agents have experienced issues, where you think, oh, this is a small issue, but actually it ends up breaking the deal. So I'm going to go through a few scenarios. Please do ask questions as we go, or just raise your hand. And David, if someone does raise a hand, please let me know, or we can have a little discussion afterwards. But please feel free to engage with me as we go on. Okay, so sometimes mistakes that seem small at the time can cause major problems for the transaction. We'll see some of those examples as we go through. But also at times you think, oh, flip, I didn't get this issue done. Oh, my deal is now falling flat, but actually it's not. And the idea is to kind of distinguish between the two. When is an issue material and when is it not? It's good to look at these issues and bank them for future issues or future problems, so that you don't have that unnecessary stress. I always say that your role as the agent is the most crucial role in the entire process. When you sign a contract, that is the legal contract. That is the crucial moment in the legal process, and your role is so important. And making sure that contract is signed and done properly is important. So these are kind of issues that can help you in practice. You can make or break an agreement, and also, as Lee was saying, collaboration is important. You're not alone, and reach out to to me or to your preferred conveyancer. Reach out when you have issues that you are not sure about. Okay, so I want to just talk about three kind of categories. Firstly, time and notices. These are issues that often come on. When do I give notice? How does timing work? I'm going to go through some scenarios there. Then I'm going to look at marriages. It's funny, that is my anniversary was yesterday, but I'm celebrating it today. So talking about marriages is quite appropriate. And then also changes to the contract. How do you deal with changes to the contract? So first thing is notices and time. So I'm going to ask you a question, and then we're going to go through the answers and debate it out. Yeah, so my first scenario is, this is you coming to me saying the time for expiry says 5 p.m. on Friday. Is that a small problem or a big problem? Now you would think, is that a problem at all? It's 5 p.m. on Friday. Firstly, obviously, the problem is what date on Friday. So you obviously put the date, it's very important. But also 5 p.m. What does 5 p.m. mean? Are you dealing with a local person, or are you dealing with a person overseas? So it's very important to pay what timeline are you talking about? So if your contract doesn't say that, you should say 5 p.m. South African Standard Time, in case some clever party says, oh, well, it was 5 p.m. UK time and it expired, or something like that. So be very careful. Just that kind of small detail that can potentially cause a problem. Okay, so next question. The domicilium address, and that's, you don't know, domicilium is your legal address. So it's got a domicilium address. It means that if you have it in your contract and a document is sent there, it's deemed to have been delivered, even if you are not there. That's a bit of a clue to my question. The domicilium address is for the seller is the house we are selling. Is that an issue? And the answer is not really an issue, but think about post the transfer. Let's think about a situation where post transfer the buyer moves in and discovers a major defect. The seller has now put their home as the domicilium address, and they have moved across to another town or into a retirement village, or they're no longer there. Can the buyer then address the notice to the property they just bought? Theoretically, yes. So they could send the legal notice to the address that they're living, because that is the domicilium address for the seller. So just be careful in those issues. Maybe have a situation where you say, my domicilium address is now my new address, or put an address addendum or something to that effect to say, this is my new address. So just bear that in mind. Okay, so the next thing, this is now where it comes to really interesting issues when it comes to the notice clause. Your 3 days notice, or your whatever you call it, 72-hour notice, whatever your contract says. The question is, I sent the 72-hour notice by email to the first purchaser. This is how we've been communicating. Should I be worried? And this is a crucial point when you look at your contract. Your contract is so crucial because it guides the entire transaction. Where you need to look is at your notices clause. The notices clause says, these are the addresses where I will receive notice. It's either a physical address, and some people still have faxes, believe it or not, and then also an email address. If your notice clause does not have an email address on it, and you send it by email address, that notice has not been sent properly. So when you have to send a notice, either a breach notice or you have a competing offer, and you want to give notice in terms of the competing offer, please make sure you do it in terms of your notice clause. Understand how your notice clause works and make sure that you send it via the notice clause. And if your notice clause does not have an email address, please make sure that your notice clause has an email address, because that is the way that people now communicate in terms of notices. Otherwise, you may have to post it or send it via registered post. So be very important when you give notice, make sure that you look at your notice clause, because the buyer will say, well, I didn't get notice in terms of the contract, and therefore I am not taking the notice. Because buyers will look at, or the other party wants to enforce their rights, they'll say, well, I didn't get notice. And we've had this a lot in practice, where notice has been deemed not to be given because it wasn't given properly in terms of the contract. Okay, so those are issues on notice. Any questions on that? Any comments?
I think can you try to go over that address? And I think there's a bit of a conflict with your explanation for me, that the notice comes to the place where the buyer was selling. So I don't think, do you have another way of explaining it? I don't think I'm getting it.
Yeah, sure. Thanks, Simon. Okay, so the domicilium address is your legal notice address where you will accept legal notices. If you put the seller's address as the legal notice address, and they, after transfer, have moved to a new address, and the contract is still in place because it's a contract, and there's something that goes wrong, the buyer can then issue a notice. And where do they issue it to? The address that's on the contract. And if the address on the contract is the seller's address, the property you're selling, they can potentially send it there. That's why it's important to not only have a physical address there, but also an email address, so that you can make sure that the notice is received by the seller at an address that you know they're at. You don't want to give the buyer or any party an excuse or a technical excuse to take action against someone where they're actually not there. Does that make sense, Solomon? It is a bit of a technical issue.
So in other words, that needs to be covered in that contract under your FICA.
Yes,
in other words,
yeah.
You say you need to have two places. The one address that's physical for the seller, and then the other address it's for the house that's actually being sold.
Yeah. So what I would recommend, and this is up to you and David, maybe you can put this in your contract, is to say, this is my domicilium address before transfer, and this is my domicilium address after transfer, so that you have so that it covers both. It covers both. But ideally, you don't just want the physical address; you want the email address as well. I doubt anyone here does not have an email address in their contract, in the notices clause. Hey, David? David, are you there? Okay, take home.
I missed you there. Carry on.
Sorry, they're asking about your domicilium address.
I'd have to check it. I can't remember.
Notices clause.
Yeah.
Just make sure that all your notices clause have an email address on it. Lee, in your contract?
I'll check.
Cool. Okay, we'll take it offline. Okay, so is that clear? We'll move on to the next issue that I find problems with is marriages. Now, I'm not talking about issues in marriages, but issues relating to your marital regime. Okay, so this is where I often find problems in terms of how people are married. Okay, so this is a question you could ask me. Ulrich, the purchasers are married by Zimbabwean law. I reflected them as married in community of property and insisted that they both sign the agreement, although they only wanted it in the wife's name. Is that a problem? So the answer to that is that if you are married according to a foreign marriage, it's not in or out of community property. You must mention the foreign marriage. They're married by Zimbabwean law, because we don't know the law of the other country. The deeds office especially say we don't know the law of the other country. So you must say it's a foreign marriage and what that country is. So the fact that you reflect them married in community property is wrong. You must actually reflect them as married by Zimbabwean law. And the fact that you insist that they both sign the agreement, that's fine. They can sign both the agreement, but if you are married by foreign law, one party can sign the contract. Only one party can sign the contract. Both parties don't need to sign the contract. But if they are getting a bond, then the bank will insist that the spouse join them on the bond application. That's when both parties should be on the agreement. So make sure that you ask the right questions. How are you married? By what law are you married? Don't just take their word for it. Ask them and then record that they're married by foreign law. Now, on the flip side of that, very important to note that when a person married by foreign law and they are the single owner, let's say I'm married to Andy I'm Swedish, let's say I'm married by South African law, but this is an example, I'm married by Swedish law, I own the property, and now I sell the property. The deeds office will insist that my wife assists me, even though I own the property, because the deeds office will say that according to our law, we don't know the laws of other countries, so we will assume that you're married in community property, and then they will require her to assist me in signing the documents. And then in that case, then both parties will sign the agreement of sale. So just make sure that you flag an issue when it comes to foreign law and make sure that is dealt with and that you ask the right questions. And this is where collaboration is important. It is complex when you're talking about foreign marriages. Reach out to me, to your friendly conveyancer, and make sure that you deal with it properly so that you don't miss an issue when it comes to marriages. Okay, so second question. I thought they were married out and now I see the purchaser is married in and the contract is already with the lawyer. What must I do? Now, this often happens where you take your client's word for it, that they are married in a certain way. They say, oh, well, we are married out of community property. And then later the lawyer contacts you and says they're actually married in community property. So if you are married out of community property, you don't have to, you can buy the property on your own. You don't have to have your spouse to join you. The question is, if you are married in community property, do you need your spouse to be part of the contract? Now, I'm going to be very careful what I say here because I don't want to confuse you. And lawyers do tend to confuse people when they, that's why I say lawyers have a job, because they confuse people. But the law is that if you are married in community property and you buy property, your spouse does not have to consent to the sale. Okay? So in that case, but legally, you can carry on with the agreement. But where the problem comes in is when the buyer gets a bond. If the buyer gets a bond, the bank will insist that both parties are party to the contract. And therefore, both parties must be on the contract. So very, very clear distinction between buying and selling. If you're buying and you're married in community property, and this happens to you, it's not necessarily a train smash. I always recommend that you put both parties on the contract if they're married in community property. It's very important because you do away with a lot of issues. But legally, by law, when you're buying property, your spouse does not have to consent. Both parties' names will be ultimately on the deed of transfer, but they don't both have to sign the agreement of sale. But please don't do that. Put both parties' names on the contract. It's only if you rush to David, I've got a problem here. Both parties are the parties are married in community property. What do I do? And in that case, it doesn't invalidate the contract just because one party has signed the offer as the buyer. Now, on the flip side of that, if you are married in community property and you sell, then the law is very clear. Both parties must be on the contract and they both must sign the contract because they are now alienating the property. They are selling the property. And that's very, very important. Both parties must be on the contract. Okay. My final question on this issue is the wife did not sign the sole mandate and now they are arguing that the sale is invalid as they are married in community property. Help, what do I do? Okay, so in this case, it's a sole mandate. Okay, so that's your sole mandate. The wife and the husband were married in community property. The wife signs the sole mandate, or the wife didn't sign the sole mandate, the husband signed the sole mandate, and the property was sold. And now they're married in community property, and the wife is saying that is invalid. Quick one, that is a case. Actually, was a case, a legal case where these were the facts. facts. It was Rawson's properties that had the mandate. I don't know where in which city. The wife argued that there was a sole mandate and therefore they were married in community property, and she didn't sign the sole mandate and therefore it's invalid. Good news for you is that the court argued against that. Very important that when you sell property, as I said earlier, you have to have, and you're married in community property, both parties must sign the sales agreement. And that is because you're alienating property. A sole mandate is not alienation of property. A sole mandate is a contract. And a contract that doesn't require both parties to sign. So the husband signs a sole mandate, the wife doesn't sign a sole mandate, and you sell the property, you are going to be safe. But don't obviously leave that to chance. Make sure that you do your homework beforehand, that both parties do sign a sole mandate. The court argued that they were trying a technicality to get out of the sale, and the mandate was signed, and the property was ultimately sold. So the wife didn't have any objection to the property being sold, even though it was sold through another agent. There was a sole mandate signed, and that they can therefore claim their commission. So just bear that in mind. In that case, the agent was an innocent party. You as the agent, relied on the signature of the party, and you were the innocent party there, and therefore you can rely on the sole mandate, and the commission claim was successful. So just bear that in mind. It's not always said clear cut, you see. So you think, oh no, I'm dead in the water. But actually, if you understand the law, you can make sure, get the right advice and make sure the transaction does go through. Okay, so that's issues on marriages. Any questions on that?
Few minutes, Ulrich.
Okay, thank you. I'm on my last one. Okay, questions, guys, on the marriages? Okay, cool. I'll take that as no, and I'll move on to the next one. Change to the contract. This is a big one.
Hi, Ulrich.
Yes, sorry.
Sorry, I put my hand up late. So I just wanted to ask, so when you, excuse me, when you are doing like international law with the marriages, do you have to research like the Zimbabwean law or anything of that sort?
No, you don't. You just have to record how they married.
So you just record. Do you take what they say as, like you were saying with the in community and out of community?
Yeah. Then let's just give you some sort of proof how they married, or some declaration. We are married. You were married in Zimbabwe, and we married by Zimbabwean law. You don't need to do the research at all here. I think what's important is that if you're unsure, you speak to your legal consultant, because it's interesting that you mentioned that, because in our country, we have the law of the domicile of the husband. So if the husband is domiciled in Zimbabwe and they get married in another country, the law of Zimbabwe governs their marriage. So the question you can ask is, where were you living when you got married? Where was the husband living when you got married? And that is the law that governs their marriage. Generally, people should know what law governs their marriage. If there is any uncertainty, reach out to someone like me just to give you some advice. But it's important to get it right first time. Does that help?
Yes, no, thanks, Ulrich.
Okay, great. Okay, change to the contract. I'll go very quickly. This is where I spend a lot of my time in this space, is looking at changes to the contract. I forgot to get the witnesses to initial every page, and now I can't find them, and I can't find the witnesses to initial. Is that a big or small problem? And the answer is, it is a very small problem. You do not need witnesses for a contract to be valid. So witnesses are good to have. It goes to evidence at the end of the day. You do not need witnesses for the contract to be valid. So do not panic if you can't find the witnesses. They are not essential to the contract. It's a good to have, and I would recommend it, but if it's not possible, our law accepts it. Our law contract accepts it. Both the parties must sign. You do not need witnesses. Okay. Next question. I deleted the clause relating to the seller being a non-resident, and that is not applicable, but I forgot to get the purchaser to initial the change. Is that a problem? So there's a clause saying that the seller is a resident or non-resident, and you have to delete it if it's not applicable. And I forgot to delete it. Or I forgot to get the purchaser initial next to the change. Is that a problem? And the answer is no, it's not a problem because it's not material to the buyer. That clause is not material to the buyer and he didn't initial it. That is fine. You don't have to worry about that. The issue is of materiality. If I delete the purchase price and I increase it by 100,000 Rand and I don't get the initial purchase to initial that, yes, that is a problem because that's material to the contract. So just apply your mind to the change. And if for some reason you forgot to get someone to initial, which does happen, we are busy, we're stressed, and sometimes we forget initial, just before you panic, to say, is this a material change to the contract? Does the purchaser need to initial here? And just consider that. In this case, it's not a material change, and therefore it's not a problem at all. Okay, last question, one more page after this. Is it a problem if I added the name and signature of the wife after the purchase is signed and did not get them to initial? I realized that the property was in fact in both names. That's an interesting one. If we were in person, we were debating this one. But is it a problem if I added the name and signature of the wife after the purchase is signed and did not get them to initial? That, in my view, is fine. The seller, the wife is a seller, therefore they must be on the contract. It doesn't change the fact you're still buying from the owner of the property, and the owner of the property is that person as well. So adding that person's name does not change the materiality of it because they are the owner. So that's my view. So that's not a big problem in my view. Okay, the owners are the owners, and you can put them in. Okay, next one. Is it a problem that I initial after filling in a blank space, such as the deposit clause or date of transfer? This is also a very interesting thing. Your contract is pre-populated. It has lines that are blank and you fill it in. And some people, you write in the blank space, initial next to that. Is that a problem? There are two schools of thought there. My view is that I would not initial there because it is already there to be filled in. That's meant to be filled in, and therefore it's not a change. It is meant to be completed. Don't initial there because that leaves it open to someone then changing what you've already filled in there. So the other school of thought is you can initial, but my view is if there's a blank space, don't initial next to the blank space that you filled in because it's pre-populated, meant to be there. Okay. Next question. Oh dear, I wrote in a special condition that the purchaser can do some improvements before transfer, but forgot to delete the standard clause saying she can't. So there are two clauses. The one is pre-populated saying that the buyer may not do any improvements without the consent of the seller. And then I wrote in a special condition at the bottom, said the buyer can do renovations before transfer, and you elaborate there. And now there's a clash between the two. What must I do? And I forgot to delete the standard clause. Obviously, you can try and delete the standard clause and get an addendum. But the law is clear that if there's a conflict between what is pre-populated and what is written in or typed in afterwards, the typed in part takes precedence because that was intended to be put in. So if you find that and it causes a big problem and the party who tries to get out of the sale because of that, they can't get out of the sale because the condition that you wrote in trumps the standard clause in the contract. Okay, last one. We will end. Flip. I forgot to delete the options for vacant occupation versus the occupation subject to existing tenancies. What now? And this is a true story. I had that where you have an option where the property is sold and there's a tenant in the property, and there's an option where there's vacant occupation versus occupation subject to existing tenancies. Please make sure you address that and delete, especially if there is a tenant. Because if you keep both open and there's a tenant in it, who wants the tenant? Does the buyer want to take over the tenant, or does the seller, is the seller responsible to get the tenant out? And I had a real live example like this, where the seller sold the property, there was a tenant in it, the buyer bought the property, didn't want the tenant, the agent forgot to delete this, the tenant didn't move out, so the buyer inherited the problem. Thankfully, we negotiated the situation and everyone was happy at the end of the day, but it caused a major problem. So if there is a tenant, make sure you address this issue. Vacant occupation versus occupation subject to tenancies. Are you taking over the tenant, or must the tenant vacate? Then it's the seller's responsibility to take action to get the tenant out of the property. So be careful when it comes to those options in your contract. Make sure you delete it to avoid issues going forward. Okay, so that's it. So sorry, that was a very, very fast quick quite a lot of issues there to think about and discuss. But please do reach out to me or to your friendly conveyancer if you have any issues. The key here is that contract is complex, and lots of issues can arise in concluding a contract. And sometimes it's something that you haven't thought about, or something that you pick up after the fact. The key is just to slow down when that happens, consider the consequences, and seek advice, ask around. It's also important to know these issues as a red flag to avoid that in the first place. So make sure that you really do apply your mind when dealing with those issues. Any questions? Do we have time for questions? I know
thanks, Ulrich. So two things. First of all, Ulrich, if you can just put your details in the chat box so we've got it there. Guys can contact you. So we are going to have questions. So I know we are a little bit over time, so I want to respect everyone's time who needs to go. If you do want to go now and you do need to go, please excuse yourself. But absolutely, Ulrich, if you've got a few more minutes to answer questions, that'd be great. Thank you, everyone, and we'll see you in the morning. But yeah, let's those who want to stay for questions, please feel free to stay on. Okay, go for it, Andres.
Good day. You know, on the offer that section where you give a timeline or specific number of days for to obtain a bond. When does that counting start? Does it start when the purchaser has signed, or it starts when the purchaser and the seller have signed this offer to purchase?
Yeah. So the agreement of sale is concluded on acceptance or last signature, the date of last signature. So yeah, so it's the date of last signature or the date of acceptance. Usually it's the date of last acceptance, which is the date that the seller has accepted it. Sometimes the buyer does sign it after the seller, but generally it's the date that the seller has accepted it. And very important question, Andres, you calculate the days, you exclude the first day and include the last day. So if the date of sale is on a Monday, and let's say 5 days, your first day starts on Tuesday. You start counting on Tuesday. Okay. So you exclude the first and include the last. That's how you work out. Does that make sense?
Yes, it does.
Great. Okay, then Solomon, your hands up.
Yes, I wanted to ask, there's actually a couple of conveyances that are giving slash reward or commission to agents that are bringing business to them. Is that not an issue? Is that also not impacting auditing and slash our FFCs, etc., etc.? So I just wanted to understand, because I know from bond origination, then that's okay, because the money, the bond originator gets paid by the bank. So that percentage, they're able to share a bit of that percentage with the agent and rewarding them for bringing the business to them.
Yeah, that's a very, very good question. And it's something that is an issue in our industry. So I totally understand the concept of a referral fee, that I refer work to you and therefore can I get a referral fee. However, the nature of law is a bit different. Law is, because you're applying legal principles and legal issues, the issue of conflict of interests arises. So you have to advise your client in a free and fair environment. There's no conflict of interests. Someone comes to you for legal advice to transfer property, you've got to act in their best interests as a lawyer to make sure the transaction goes from A to Z and gets over the line. You act for the seller, and the seller is your client. So there is a prohibition in law, in South African law, for South African lawyers to pay referral fees for work. Now, the funny thing is that we can receive a referral fee from you. So if I refer work to you, you can pay me, but I can't pay you, which is an interesting thing. And I totally understand the concept of referral fees, but in law, you have to be totally independent. So if I now pay someone a referral fee for a transfer, that ruins that relation dynamic. Who do I act for? Am I acting for Solomon, or am I acting for the seller? So you've got to be very, very careful when there are fees that are changing hands from a lawyer to a referrer. So this is rife in our industry. It happens all the time. There are lawyers that do pay for work or give referral fees. That is against our code of conduct, and that's actually illegal. So I do believe in relationship. I do believe in rewarding relationship, and that there are business partner relationships. But that's through building your practice. So where I would contribute to someone that supports me is something like this: is to support this event because it actually improves the industry. And it's marketing for me. You hear my name, you hear me speaking. That's marketing for me. That's how it should work in this type of relationship. But for me to actually pay you for getting an offer, that creates an inherent conflict of interests. Who do I act for? If you and now the seller have an argument on the commission plan, who do I act for? That's really the question. And unfortunately, the industry is rife in this situation, and we don't accept that kind of referral work. We deal with it in a way more of a relationship building aspect.
So, Ulrich, they're just lawyers, eh?
Sorry?
They're just lawyers.
They're just lawyers, yeah. What?
Lawyers, yeah. Okay, great. Any other questions?
Good answer.
Are there any other comments or questions, guys? Are we done? Again, do that. No one else has got their hands up. Ulrich, once again, really appreciate your generosity in assisting not only with the talk this afternoon, the presentation late this morning, but then also with your sponsorship. We really do appreciate it. It has been awesome so far. Everyone, thank you for attendance. I know that we're running over. I want to honor everyone's time. We'll see you 8:30 tomorrow morning. And once again, we'll be having our Power Up Your Sales Conference sponsored by GSM starting at 8:30 tomorrow morning. I have sent the links through. If there's any challenges of not having the links, please just be in touch. Thank you.
So, guys, just last word from me. Thanks, David, for giving me the opportunity. Do you feel free to reach out to me? I know there are quite a few questions that probably have come up in my talk, but feel free to reach out to me. And if you want to engage on any issues that I've raised, I will send the slides to you. I think I already have sent the slides to you, David. So you can distribute the slides. I know they don't have much information, but if you have any questions on that, please feel free to reach out to me. And thank you for the opportunity. I'm not going to see you guys again, but enjoy the rest and just lap it up. And the goal is for everyone just to get better and collaborate. And it's tough out there, but I want to encourage you just to put your eyes on the prize, do what you do and do it well and with integrity and honesty. So thank you, David. Thank you, appreciate the opportunity.
And, thank you, everyone. Chat soon. See you.
Cool. Cheers, guys.